Okay, good afternoon, everybody. It's 3:15. My name is Lynn Tran. I'm a senior attorney advisor to the Board of Ethics and Government Accountability. This is our first kind of code of conduct game show that we've had at Ethics Week, so thank you for joining. This is going to be an interactive process. I hope you guys are ready to participate. I've tried to adjust some of the settings so that you should be able to put questions in the chat. So if you have any questions during this process, just let me know. And I hope you guys have enjoyed the Ethics Week programming to date. I know we had some interesting panels this morning. Director Cooks gave us all an update on what's been going on with BEGA. Masi Maslow did her ethics game show, which is different than what we're doing here. And I know our investigators also walked you through our investigative process. So moving on. This is our Code of Conduct game show. It's the first one we've done, and it's specifically focused on the district's Code of Conduct and the different provisions. It's intended to test your knowledge of the rules and also to kind of show you, give you a sense of our thought process over in BEGA when we're answering ethics questions. So how do you play? First of all, what we're going to have is I'm going to have a variety of scenarios that are drawn from real world examples. These are from OGE's negotiated dispositions, advisory opinions that have been issued, and informal advice that we've given. It's also drawn just from my and other people's extensive experience, just answering questions both here at BEGA and elsewhere as well. What you can do now is go over to slido.com, and I'm going to give you the number for the quizzes that we're going to be doing, and a vote on. We'll give you a panel, each a question, and you have a selection of answers, and you can vote to see what you think the answers will be, and you'll see how your fellow ethics counselors approach the same problem, and we'll keep a leaderboard going. If everything works okay on the tech front, we should have an ability to conduct these polls and have a running leaderboard to see which ethics counselor or whoever participating has the most knowledge of the district's Code of Conduct. Oops. So you can join at slido.com, and this is the number that you want to put in, 3301-478. And you'll be able, again, to vote on the polls that are coming up. So do we have any questions initially before I move on to the first scenario? I want to give people time to sign up. Let me check the chat, see if we see anything. People able to join up okay? If you can join, let me, if you drop something in the chat and let me know. Okay, great. I see that people are joining. Excellent. So we are going to move on, and you'll have some time to think about the questions as well when you're voting. So I'm going to move on to our first scenario. So scenario number 1. Andrew is the chair of the DC Health Benefits Exchange Board. Andrew is a partner at a law firm in the district, represents a technology company owned by Brian. Brian's company submitted a bid for a contract with the DC Health Benefits Exchange. When Andrew sees that Brian's company is on the agenda for the next board meeting, notifies the agency director of his business relationship with Brian. At the meeting, the agency's staff recommends that the board approve the contract with Brian's company. The board votes in favor of the recommendation. Andrew does not vote on the contract, but he signs the resolution approving the contract in his capacity as chair of the board. So, what do we think? Did Andrew violate the conflicts of interest rule? This is not the voting slide. You'll have a voting slide coming up, but I want to give everybody a little bit of time to think about these answers. Did Andrew violate the conflicts of interest rule? No. Brian is not closely affiliated with Andrew. No, Andrew recused himself and did not vote on the contract. yes, Andrew signed the resolution approving the contract, or yes, Andrew violated the conflict of interest rule, but for a different reason. So again, I'm going to go over to, oops, that's me, Slido. We have 30 seconds to let you guys vote on what you think. So what do we think? Can you guys see the quiz? I just got something in the chat that suggests somebody couldn't see it. So we have 75% of the people saying that there's no violation because Andrew recused himself and did not vote on the contract. 17% of the people said there was a violation of the conflicts of interest rule because Andrew signed the resolution approving the contract, and 8% said yes, he violated the rules, but for a different reason. So this is a really good example of kind of the importance of talking through the issue. And we're going to talk through these different scenarios, and I'm going to, first of all, give you guys the answer. So we would have accepted two different correct answers. Yes, Andrew violated the conflict of interest rules because he signed the resolution approving the contract, or yes, but for a different reason. So why? Let's see, leaderboard, we got quite a few people who got it right. So why were there two different answers, and why did 75% of the people say that there was no violation because there was a recusal? Well, first of all, the first point is that Brian's company is a client of Andrew's, which meets the definition in the code of closely affiliated entity. So a few provisions to keep in mind. DC official code 162.23a. No employee shall use his or her official position or title or personally and substantially participate through decision, approval, disapproval, recommendation, rendering advice, investigation, or otherwise in a judicial other proceeding, request for a ruling or other particular matter, or attempt to influence the outcome of a particular matter in a manner that the employee knows is likely to have a direct and predictable effect on the employee's financial interests or the financial interests of a person closely affiliated with the employee. So Brian's company is a client of Andrew's, and that is an entity that's closely affiliated with Andrew. Now, another provision to keep in mind is GC Official Code 1162.23c, which requires an employee to make a full disclosure of the financial interests in the form of a written statement describing the matter and the nature of the potential conflict of interest, and deliver the statement to the employee's supervisor and to BEGA. And I think the 75% of you who thought that there wasn't a conflict probably were thinking of this provision, that the recusal provision. But notice that the recusal provision says that there's a requirement for a written statement, and that the statement go to the supervisor and to BEGA. What we have in the facts of this case is that Andrew notified the director, but did not follow this specified recusal process. So the conflict is still there. And the reason that signing the resolution is a violation is we still have this conflict, the recusal is not in effect, signing the resolution is an official action, but the other official action to keep in mind is that Andrew was also participating at the meeting. So he was at the meeting, he was there for the discussion, he did not properly follow the recusal process. So that's why we would have accepted two different answers for why there was a conflict of interest in this case. So I'm gonna go over and check the chat and see if anybody has any questions at this point. Okay, if not, Asia, is there anything in the chat?
I'm not seeing anything.
Okay, great. I'm going to move on to the next one, but that was an interesting split that we had there. Okay, next question. Scenario number 2. Charles has worked in the office of the Chief Financial Officer for several years. Earlier this year, Charles was involved in discussions with Company D about plans for the company to develop a project in the district. Charles attended multiple meetings with Company D, but has not worked on the matter since that time. Earlier this week, Company D contacted Charles to see if he was interested in a position with the company. Charles met with representatives from the company on Wednesday to discuss potential employment. Later that day, the mayor's office contacted Charles to ask his opinion on proposed changes in the contract with Company D. Should Charles advise the mayor on the contract with Company D? Yes, because Charles did not enter into an agreement for employment with Company D. Yes, because Charles can seek a waiver of any conflict of interest from the mayor. No, because Charles has entered into employment negotiations with Company D. Or no, unless Charles rejects the possibility of employment with Company D. So let's see what everybody thinks. Ready? And so here are our options again. Should Charles advise the mayor? And we'll need to vote at the Slido in order for your votes to register so you can see yourself up on the leaderboard. And again, yes or no, but also why? Okay, what do we see? So 6% of you said yes, because he didn't enter into an agreement for employment. So it's okay. Yes, because Charles can seek a waiver from the mayor. No, because Charles has entered into employment negotiations with the company. That's by far the highest percentage, 72%. Or no, unless Charles rejects the possibility of employment with Company D. I'm glad we're seeing a split here because I tried to make these questions a little bit, tricky so that there wasn't a clear-cut answer. So let's see what the answer was. And the answer is no, because Charles has entered into employment negotiations with the company. But again, let's talk through some of these other answers. So it's very odd because I feel like some of you guys probably got both of these correct, but it's not registering. So we'll deal with that when it comes to giving out the prizes at the end. So why is the correct answer no? Again, the provisions to keep in mind is the definition of person closely affiliated for the purpose of the conflicts of interest provision includes an affiliated organization. And that includes a person with whom the employee is negotiating for or has an arrangement concerning prospective employment. So the issue, for those of you who said no, there's no arrangement, you don't actually need the arrangement. And what you need is just to enter into discussions of the terms and conditions of employment where you haven't rejected the possibility. So, Charles has entered into employment negotiations with his company. He met with the company and, he doesn't have to enter into that agreement for the conflict to exist. So negotiations is by far the more common trigger than entering into an actual agreement for employment. Another thing to keep in mind is that employees no longer seeking employment when the employee or the prospective employer rejects the possibility of employment and all discussions of possible employment have terminated or a reasonable amount of time has passed. Here, the discussions didn't terminate because Charles didn't say, no, I'm not interested, and time has not passed. So generally, I think you look for is, say, about 2 months if you send in an unsolicited resume. But what we have in this case is somebody who, the same day as the meeting, was asked to weigh in on an issue of interest to the company. And again, we talked about this in the last scenario. There are rules that allow for a waiver, and there's a process. And Charles didn't follow that process. So process, again, includes a full and complete written statement describing the potential conflict to BEGA and the supervisor and an advance written determination. No such determination was made in this case. So there's no waiver that's in place. And I would say that for rejecting the possibility of employment, that would need to occur before the conflict presents itself in order to deal with the potential conflict issue. So I saw some stuff in the chat. Let me see. Asia, can you tell me what questions people have?
Sure.
I saw some things popping up before we move on to the next question.
Yeah, I'm not seeing many. Someone asked, can we see the scenario?
I'm sorry, Asia, I can't hear you.
I'm sorry. Is it low? I'm sorry.
Yeah.
Sorry, my volume is all the way up. I'm not quite sure why you can't hear me.
I can hear you very faintly, but let me see. It seems to be that we're having a problem with the leaderboard, in which case I'm going to suggest that everybody keeps track of the number of questions that you have correct, and we'll just do a ad hoc leaderboard at the end. But as long as people are still able to vote on the questions, which it seems like we're getting votes because we're getting tallies.
Yeah, it just seems to be concerns about that, but I didn't see any
Okay,
questions.
so let's ignore the leaderboard and keep your own count and see, and we'll do a check-in to see how everybody's doing. So I'm going to move on. If there are no substantive kind of questions about this one, we'll move on to the next one. Okay, scenario number 3. As part of her duties for the Department of Parks and Recreation, Erica ran a computer skills training program for senior citizens. After DPR discontinued the program, Erica started a company providing training services and now offers her own computer skills training to senior citizens. Erica is careful to keep her program separate from the DPR program by creating new training materials and using her personal computer and equipment to conduct the program. Erica usually conducts her trainings in the evenings, but occasionally schedules late afternoon trainings. She takes leave if her trainings start before the end of her duty period. So, can Erica continue to conduct her training program? Is this a violation of the code of conduct? Yes, no, and catch all, maybe. So let's see what everybody says. So what do we think? Is this training program that was based on a DPR training program okay for Erica to continue as her own outside business? Okay, let's see what everybody says. So we got yes, some no, and a lot of maybes. And that's because it depends, right? And it's hard to say definitively whether it's going to be absolutely yes or absolutely no without some additional information that I have on purpose not given you. So a few things to keep in mind. So again, the question is purposely vague. Few provisions that we want to keep in mind is whether Erica is conducting the trainings in the office, which would be a violation of the rules against using district resources, office space, equipment, or outside activities. So again, DPM 1807.1a, district government employees shall not engage in any outside employment, other activity incompatible with the full and proper discharge of his or her duties and responsibilities, should not be using government time or resources other than for official business or government approved or sponsored activities. DPM 1807.2 allows employees to receive compensation for teaching if conducted outside of regular working hours while on leave, comp time, exempt time off, leave without pay. And then DPM 1808.1, employee has a duty to protect and conserve government property. So what I didn't tell you is whether Erica was in the office conducting these trainings, whether she was teleworking at the time, and whether she was on official time or whether she was off duty. So it depends. Where is she when she's conducting these trainings? We already discussed in the scenario that she's not using district resources. So she's not taking training materials that were produced for the district and using them for her own outside business. That would present a separate problem. But if she's conducting the training in the office, that's a problem. If she's using her district issued laptop, that's going to be a problem. And the board recently resolved several matters where employees were engaged in outside employment or business on district time, in district space, or using district resources. So this is something that comes up a lot in the cases that we've been seeing, especially with the increased advent of the telework and the, people feeling that the boundaries have kind of blurred between when they're working and when they're not working for the district and not working. So let me do a check-in, see if we have any questions. And then, I'm not seeing anything here.
I'm not seeing anything.
Here. Okay.
Can you hear me better now, Lynn?
Yes, I can. Thank you, Asia.
Okay, great.
So perfect. Seeing like comments pop up that oh, there we go. I'm seeing more comments pop up. So
Okay,
I'm seeing some comments. That's weird.
Let me.
Now I'm seeing a
Can you
whole host of.
Yeah, they just popped up all at once. I
know.
I don't know what happened there. But the first one says, could it also be because she didn't get approval from BEGA?
Oh, for this one? What
we
we
got them all at the
approve.
same time.
Okay. If that one relates to this question, then that's not really an issue because we can't approve the use of district resources for outside activities. So that probably more likely relates to that first one, which is the recusal. The recusal requires requires that you have that written recusal that comes to BEGA. And I see Nina just asked a question about where did she get the client list of seniors from? That's a good question, Nina. We don't say. She can't use the list that was created for the agency. So she could go out and solicit her own clients. She could work with groups that she is familiar with, that she had worked with previously, as long as it was made clear that this was outside activity. So, outside activity, not all outside activity has to be approved by BEGA as opposed to your agency. So your supervisor and your ethics counselors, you guys at the agencies should be reviewing and approving outside activity, particularly where there's the potential to conflict with your duties for the district, but not all of that comes to us.
I don't know if you wanted me to go back up further, but there's one that says, why isn't the definition of an employee no longer seeking employment not part of the DC code definitions, or is curious why a CFR is cited?
So I cited the CFR just because the provisions of the CFR apply here, the employment negotiations, post-employment provisions. There is no specific definition in the code or our regulations about how much time needs to elapse before you're no longer seeking employment. So if we don't have anything else on that one, I'm going to move on to our next scenario.
I think, did you answer this final one?
Which one?
Doesn't that need to be approved by BEGA when there's an overlap in your duties? I think
I did
already.
Yeah, I did. Okay. I'm going to move on to the next one then. Scenario 4. Frank is an employee in the Office of the Chief Technology Officer, and he works on network security issues for Octo. Trade Association G sponsors an annual conference on internet privacy and security in government services. This year, the conference is being held in Philadelphia. And the trade association invites Frank to attend the conference to speak about the district's work in this area. Company H, a company based in Philadelphia, has a contract with Octo to provide services to the district. They're sponsoring an exhibit booth at the conference. Company H invites Frank to attend a dinner in Philadelphia, company officials after the conference. So, which event, if any, is Frank permitted to attend? Can Frank attend the conference sponsored by the trade association, the dinner hosted by the company, neither event, both events? Okay. Let's see what everybody thinks. And again, remember, Frank works on the issues that the conference is addressing. The company that is inviting him to dinner is a contractor, and we have two events occurring in the same place. So where can he go, if anywhere? Okay, 65% of you think that he can attend the conference. 5% say company dinner. 15% think that he shouldn't be going anywhere. And 15% say he can go to both. So where are we with the actual answer? And he can actually attend. No, that is not correct. So that's not the correct answer. He can attend the conference with the approval of Octo. Sorry about that. That's a little bit of a glitch in the system. So he can attend the conference if he receives prior written approval from Octo. So the conference fits the exception under 1803.5D, free attendance at a conference where he's a speaker because he's being invited by the conference sponsor. Company G is, Company H is not an overall sponsor of the conference. The dinner's not part of the conference, so it would need to meet a separate exception under the gifts rule because the company is a prohibited source. They're a district vendor that has a contract with Octo. Based on the information provided, it does not look like any other exception would apply. It's not a widely attended gathering because it doesn't have the number of people from the diversity of attendees. It's just a dinner with company officials. And it's not a reception. Because again, it's a dinner. So we have, if so approves Frank's participation in the conference to speak on the issues that he works on, he could attend the conference, but the dinner is not going to fit any of the particular exceptions. Do you have any questions about this one? This one's a little bit more straightforward. Again, apologies for that little glitch in the, it's a good thing we're not paying attention to the leaderboard. Okay, this one's a little more straightforward, so I don't see any real questions. I'm going to move on to the next one then. Okay, scenario 5. So Irene was an employee of the District of Columbia Public Schools until August 2021. As part of her responsibilities, she worked with MPD and the company that MPD contracted with to provide school security, including attending monthly meetings to discuss the school security contract. After leaving DCPS, Irene started a security consulting firm, Company K. One of Irene's clients is a subcontractor on the school security contract. President of the company plans to attend the next monthly meeting to meet the new MPD official overseeing the contract and has asked that Irene join him at the meeting. So, can Irene attend the meeting? Yes. Her cooling off period ended after 1 year. We specified that she left in August of 2021. No, she's subject to the 2-year restrictions for matters under official responsibility. No, she's subject to the permanent restrictions, or yes, provided she does not participate in the meeting. So let's see what we think. Let's get ready to vote. So again, Irene left her position August of 2021. She was a DCPS official and working with MPD on the contract for school security. Can she attend this meeting on behalf of the subcontractors? Okay. So we have a pretty even split. 43% of you think, yes, it's been more than a year, her cooling off period has ended. No, 43% of you think that it's a 2-year restriction for matters under official responsibility. 5% of you say, no, it's the permanent restriction. And yes, 10% say she can go to the meeting, she can kind of just sit there in the back, but she can't actually take part in the meeting. So this is a pretty broad split. Let's see what the answer is. So she's actually subject to the permanent prohibition, and we'll discuss why. So the 5% of you who got this one right, give yourself a hand, because this was a tricky one, as you can see from the split. Yeah. Few provisions to keep in mind. DPM 1811.3 provides that a former government employee should be permanently prohibited from acting as an attorney, agent, or representative in any formal or informal appearance before an agency as to a particular government matter involving specific party if the employee participated personally and substantially in that matter as a government employee. We've also got the post-employment restrictions under the counsel rule. And something I always like to remind everybody is district employees are subject to the federal restrictions at 18 U.S.C. 207 and the implementing regulations at 5 CFR 2641. 18 U.S.C. 207A1 includes parallel permanent post-employment restrictions that apply to district employees. So attendance at this meeting would be an appearance by Irene on behalf of a third party, her client. And the question is whether she participated personally and substantially in the matter as a district employee. In this case, her responsibilities while she was working for the district included the specific contract that is the subject of the meeting, explaining the permanent restrictions. And again, the restrictions under 207 apply with respect to communications or appearances. And so it's not, you can't just go there and say nothing. The appearance it's already sufficient to trigger the restrictions under 207. So again, this one there was a pretty broad split on why you guys thought it was either the 1-year restriction or the 2-year restriction. And I would say the 1-year restrictions, as we talked about, she worked on this particular contract. And the 2-year restrictions generally are if something comes under your portfolio, you're the supervisor, but you didn't work directly on it. She worked directly on it. She participated personally and substantially, which is why we're in the realm of the permanent restrictions. Do we have any questions about this one? There was a lot of different opinions about what the answers were. And again, I like to remind everyone, 207 provisions are criminal provisions, and Department of Justice does prosecute violations of the post-employment provisions. So, any questions in the chat? I'm not seeing anything. I don't know if the chat is delayed. But if
there is a possibility that it's a bit delayed. I'm not seeing anything.
Yeah, I'm not seeing anything either. Okay, well, I'm going to move on to the next one, unless somebody has a question. Okay, we're at scenario 6. Mary is an employee at the DC Public Library, and she owns and operates a coffee shop in the district. She volunteers for the campaign of a candidate for council, and the campaign has hosted several events at her coffee shop. Mary understands that she cannot fundraise for the campaign, so she's not listed as a co-host on any fundraisers, although she's hosted some smaller meet and greet events. Mary maintains a personal Facebook page and Twitter account where she posts events that occur at her shop, including events hosted by the campaign. Her posts include sharing information provided by the campaign about these events. Mary's social media account lists her position with the district in the biographical section only, but it's clear that the accounts represent her personal views and that they're not intended to be official accounts. So, what do we think? Has Mary engaged in campaign activity that violates the Local Hatch Act? She hosts these events. She's never a co-host, I'm sorry, she doesn't co-host the events, but they're at her place of business. She posts about them on her personal accounts only, but she does post information about these campaign fundraising events. So what do we think? Has she engaged in campaign activity that violates the Local Hatch Act? So I see some yeses, some nos. Let's see what our polls say. 59% of you say yes, 41% of you say no. So again, pretty broad split. What's our answer? Yes, she has. And let's talk about why. So she's actually engaged in campaign fundraising in violation of the Local Hatch Act. So the Local Hatch Act provides that an employee may take an active part in the political management of political campaigns, may not knowingly solicit, accept, or receive a political contribution from any person except if they filed as a candidate, and there's parallel provisions under the council rules for council employees. So by posting about and sharing information about these campaign events, Mary is engaging in campaign activity. While many of the posts are permissible that she's making, so she's saying, you know, these events are occurring, when she's posting links to campaign fundraising materials or sharing campaign invites to fundraising events, that's a solicitation. Even if it's on her personal account on her own time, even if she's not trying to use district resources, on her own time, using her own accounts, she still can't be soliciting for the council campaign. So the problem is not just that she has events at her shop, it's that she's publicizing the events with links to the fundraising. So she can't, there's a question about whether she could run as a partisan elected position while a district employee. So she can't be running for a partisan position while in the district because it's regulated by the Board of Elections while she's an employee. So if she were running for a nonpartisan position, ANC, State Board of Education, she'd be okay, but not for partisan positions. And somebody notes that she lists the library as an employee on her page. And again, simply listing biographical information, that's not really the problem because she's not suggesting that the library is sponsoring the campaign fundraising events. It's really the solicitation by posting the flyers, the fundraising links, you know, hope you can join us for this event at my coffee shop. And it's a campaign fundraising event. You're soliciting campaign funds in that case. So the question is, can she run for positions outside the district? Yes. So if she were somebody who resided over in PG County and she wanted to run for a partisan position out over in PG County, then yes, but she's not going to be able to run in the district. So I'm going to move on to, let's see. I'm going to check in with everybody. How's everybody feeling about how the game is going? You guys getting the answers correct? Has anybody gotten everything correct so far? I know we're down to there was one question where 5% of you got the answer right. So those 5% of you, if you got the rest of them correct, are in the running to get the perfect score. So how's everybody feeling? We've got one question left and then I'll take some questions. So somebody started the game late, not good. So I will note also, I on purpose made these questions very difficult, not unnecessarily so, because again, they're drawn from real life examples, but is to show that there's not necessarily an easy answer to some of these questions. And a lot of it depends on, you know, all of it depends on the very specific facts of the scenario we're dealing with. And also that way you guys can make sure to contact us and we'll help you talk through the problems. So I don't want to make people feel like they don't understand the rules, but I want you to understand that this is not easy. And what you guys do, like on a day-to-day basis, serving as ethics counselors, is not an easy job, and we appreciate it. So I'm going to move on to our last question. I hope it wasn't too difficult. So scenario 7. Patrick submitted an application to renew the liquor license for a restaurant he owns in the district. After several weeks without a response from the Alcoholic Beverage Control Board, Patrick mentions the delay with the license renewal to Councilmember R, a personal friend. Councilmember R tells Patrick to contact her office for assistance with the application. How can Councilmember R assist Patrick with the application? A staff member can contact the ABC Board for a status report. Councilmember R can contact the ABC Board for a status report. Staff member can contact the board chair to request due consideration of the application. The council member can contact the chair to request that the board acts on the application. All of the above, some of the above. What do you guys think? Let's see. And again, this is our last question, and we'll talk through this question, and then I'll answer any questions that you guys might have and see who the winners are. Okay, what do we think? So 27% of you think that the only thing that they can do is that a staff member can contact the board for a status report. 5% of you think the council member can do that, can contact the board. Nobody thinks the staff member can contact the chair. Nobody thinks that the council member can contact the chair. And 14% say all of the above, and I can't see what it is for some of the above. Let's see. So the answer was actually some of the above, and here's why. So under Rule 6B1 of the Council Code of Conduct, employee may not knowingly use the prestige of office or public position for that private gain or that of another person. And then the subsection B2 provides that the performance of usual and customary constituent services without additional compensation is not prohibited under the rule. So what it boils down to is what is usual and customary for the council member to do if he has a constituent that makes a request like this. So having a staff person call and check the status, as long as the procedure is that these are the types of requests that they will make status checks on, that would be okay. If there's a procedure for the council member to contact the agency, then maybe that would be okay. But again, you have to look at what it is that the office does, if they're following their usual and customary procedures, if they're going above and beyond for somebody because they are personal friends with the council member, that's what will become the problem. So the Constituent Services AO, that advisory opinion that BEGA issued a while back, talks about requesting due and timely consideration under the applicable regulations, which would be fines if you're contacting a board or an agency and saying, hey, I hope you'll follow your usual processes, or hey, I'm just calling to see on behalf of my constituent what's going on with their application. As long as you're doing that for similarly situated constituents, then those types of communications will be okay. But once you're starting to direct the actions of the agency, once you're starting to say, I'm requesting that you act promptly on this matter, that's before you, then that presents more of a problem, because you're suggesting that they should be putting this particular request above other requests, and that may not be consistent with what the agency's procedures are. So you should keep in mind that in terms of usual and customary constituent services requests, it needs to be based on a standard that is replicable for other constituents that come up. Are you going to do this for everybody who makes this request, or are you only doing this because it's the council member's friend? So this was, like all of the questions, intended to be a little bit of kind of a thought-provoking question, thinking through what is usual and customary, and what should you do for this constituent? What would you do for all constituents? So, do we have any questions on kind of the substance of this one before we move on? So I just wanted to see kind of, I know we were keeping our own score, but how many people got, you know, all the questions right? And how many people got one? So we've got 50-50. We got more votes coming in. We got more votes coming in. So we're still voting, I see. So nobody got 7? Three. We got 4, 5, and 6. So those of you, actually, who got 6 questions right, if you could drop your name in the chat for us, and we will see about getting you some prizes to reward you for some pretty good ethics counseling on your part. Again, I tried to make these scenarios a little bit tricky. So if you got 6 of them right, great job. Same for you guys who got 5, 4, 3. These are not easy scenarios, and they're intended to have you think through the rules and talks amongst yourself, talk to us. What we do when we have tough questions is we talk to each other. We talk to other agencies. We kind of ask around, and we like to think through these issues. So if you didn't get all the questions right, that's fine. And if you got more of them, then if you're one of the people who got the 6, again, drop your name in the chat, and we can get you some prizes. Let me see what we have. And if you have questions for us, you can contact us, BEGA@dc.gov. You can call us on our main number, 202-481-3411. You can email us at either the main email address, or you can email us personally. And I'm going to move out of this so that I can see if we have any questions in the chat. So, okay. So I'm going to just check. Asia, do we have any questions?
I didn't see anything that we missed. It was somebody inquiring about getting a copy of the slides, and I'm going to send out attendance confirmations to everyone who attended, and I will attach a PDF of the presentation.
Okay, perfect. Thank you, guys. This is our first time kind of running this type of game. I really appreciate, even with the weird tech glitches, I appreciate everybody's participation. I hope that it was beneficial. I hope you learned something, and which mostly is just talk about these questions. Talk to us, talk to each other. We're kind of ethics nerds over at BEGA, so we're happy to talk to you. Like, we enjoy this. It's fun. So don't feel like you can't call us if you have a tough question that comes up. So anybody have any questions? I can answer those. Otherwise, please make sure you, Asia, did we get the names of the people who actually won our game with 6 answers correct?
I did not get that.
I am not seeing anybody. You guys should tell us so we can get you your prizes, though.
We can give it another few moments.
Give everybody, we'll give people
forward?
some time so you can come forward and tell you. Otherwise, I'm going to end up with like another mug. Thank you guys for participating, though. You guys were great. You were very interactive. So. Okay, I'm not seeing anybody coming forward to claim their prizes.
I mean, we can give out participation prizes. If
absolutely. If nobody's going to claim it, we're going to, use the list, and we're going to draw some participation prizes.
Someone said they like the idea of the participation prizes.
Okay, well, we can do that then.
All right, we'll make that happen.
Okay, Asia's going to make that happen and let you guys know who won for the participation prizes. Thank you again for taking the time and participating in our new game. We'll have to tweak it with some new fun, and maybe you'll make it a little easier next year. Okay. Looks like the chat has slowed down, so I'll keep this open for another minute or two.